Well, hello. Welcome again. Employment Law Show. Good to have you along again this week. For the next 30 minutes, you will learn a ton. I bet you that that's guaranteed. Ways to reach out in the meantime. 1-855-821-5900 to catch Lior's team back at the firm. You can call that number anytime. help@employmentlawyer.ca. Simple email address and a website we're going to refer to. We do every week here and our radio show as well. pocketemploymentlawyer.ca. Tons of employment law knowledge built into that free and anonymous website, including the severance pay calculator, which is super handy for you for determining exactly what your severance offer should be. It's not that little minuscule amount that your boss says you're owed. That is completely wrong. We'll get some more details on that a little later in the show. And later on the show as well, Lior, we're going to tackle the topic of employment law for federally regulated employees. What is that all about? We'll get to it for sure. But we always start off with the week that was. What's going on your side?
Hey, John, I think that we keep getting busier and more calls. You know, people watch this show or hear us on radio and they say, wait a second, that is something that I didn't know, or this triggered a question that I had and now I want to ask it. Well, that's great. That's exactly why we are here on this show right now. Now, we'll teach you a lot on this show, but we can't get to all aspects of employment law in 30 minutes. But that's why you have that other option, which is to call. To give us a call, to give me a call in the office or send me an email. We'll give you that contact information throughout the show so that we can address your specific issue. No one should walk around with questions and uncertainties in their mind about workplace rights and about employment law. So if you have an issue, a problem, a question, let's talk about that. I know that there's a lot of issues that have popped up recently with respect to vaccines and with respect to layoffs, and maybe you're not treated properly by your boss or your job has changed. If you want to know what to do, and guess what? There's a lot that you can do. Then let's talk about that. You can always reach out. There's no excuse not to seek answers. And throughout the show, we'll give you various ways you can contact and get answers to those questions. But now that we know that, let's get started. Week that was, let me tell you about a situation that came across my desk. Now, I spoke with a gentleman who had been put on a leave of absence about 2 months ago because of his vaccine status. He was not vaccinated, is put on a leave of absence. He obviously was very concerned about that, didn't know what to do, didn't know his rights. Well, to his surprise, he got a call very recently from his employer saying, okay, we've decided to eliminate these vaccine policies that we have so you can come back to work. Well, guess what? When he thought about it, he realized, you know what, I don't want to go back to work. I feel I'm going to be embarrassed because people now know my vaccine status because I was the only one that was put on a leave. I don't really trust this employer again. You know, what happens if there's another wave of the virus? Am I going to be told that I have to go on a leave again? So he called me and he wanted to know, do I have to go back? Because guess what, John? His employer told him that if he doesn't go back, he's resigned. That's a resignation. So he called me. So wait a second. It is not a resignation. First of all, the leave itself, the fact that he was put on the leave 2 months ago, that is something that he could have treated even back then as a termination of employment. His employer, and your employer too, by the way, does not have the right to put you on a leave, even if it's because of your vaccine status. You can treat that as a termination when the leave starts and require your employer to pay you severance. Well, keep in mind, going back to work, there's a good reason as to why he's uncomfortable. There's a good reason as to why he doesn't necessarily trust his employer now. So no, the law does not impose on him the obligation to go back to work. It's still a termination. Severance is still paid. And I'm going to help him get that severance. For him, John, he's a 10-year employee. He's looking at about a year's severance that is owed to him. Same to you at home. If you've either been let go or if you've been put on a leave because of your vaccine status, you have rights, you have options. Now, I'm not advocating not to be vaccinated. In fact, I'm telling you to get vaccinated. I think people should. That said, if you've chosen not to, if your employment status was impacted because of that, you do have rights, and primarily that right to get severance. If that's your situation, let's talk about it.
Let's take that a little further. In this situation, it probably will and has and will continue to come up over the next little while as people kind of go back to work, COVID-19 and all that stuff. What if he goes back to work and the boss says, okay, don't have to worry about the vaccine status anymore, but I'm going to have you work over here. I'm going to change these hours. Or by the way, we've moved the plant down the street a little bit. I need you to go there when you come back. How about those type of changes? Because I know they're fairly common, right?
It is, and they've been common even more so now during the pandemic, employers making changes the terms of employment. The problem is that not every change at all is something that an employer is allowed to do. Now, yeah, if your employer moves the plant down the road, that's going to be okay. If they move it an hour and a half away, that's not okay. If they reduce your pay by 2%, you're not happy about that, but not illegal. You reduce it by 20%, big problem. So if your employer makes significant changes to terms of employment, that results in a constructive dismissal. You can treat that as a termination. And the problem with not doing that, the problem with accepting and continuing to work is you've given your employer the right to do it again. And that's the problem. So today you're taking a pay cut. Well, you thought that was the end of it. But by accepting this one pay cut, you've given your employer the right to do it again. And the next time there's a pay cut, and the time after that, and the time after that, you won't be able to do anything because you let it happen the first time. That's why it's important to stand up for your rights always.
Look, there's any confusion about stuff we talk about on the show for the 30 minutes every week, you can simply reach out to Lior and his team. They'd be glad to sit back and have a very relaxed chat with you and clear things up. 1-855-821-5900. The firm website, employmentlawyer.ca. Go there for all of the matters, more contact information, and also in the media tab, you'll find a radio station near you somewhere in the country that carries our show an hour long. We've been doing that for, I think we're coming up on 10 years now. We get a lot of great phone calls on the show. People are hungry for this information, so they ask. We talk about it on air, and we play in the back here as well. Lior, phone call number one from our radio shows coming up right now.
My brother-in-law, he has been working for 22 years as a machinist. During he's doing one machine job, they come over and a new manager says, hey, listen, sign these papers. It's for your new benefits and stuff. He signs them and he goes back to work. 2 weeks later, we got to let you go. He goes, what? He goes, we got to let you go, and we're giving you a week, a year.
Huge red flag, a new employment contract.
So my biggest concern here for him is that a new employment contract may have terms that limit his severance. In fact, it's likely that that new employment agreement tries to limit his severance. And by the way, same with you. If you're working, you have a job, everything's fine, but then all of a sudden your employer comes to you one day and says, we need you to sign a new employment agreement. Be very concerned. There's a good reason why they're doing that, and that is because it's better for the employer. And it's likely one of the things that it does is it removes or eliminates some of your future severance. So you have to be very, very careful with that. Now, obviously, I don't know the circumstances. What I do know is that after 22 years of employment, this person is owed a lot more than a week's pay, a week's severance for every year of service. So how much is he owed? Let me show you, not just tell you. Let's go to pocketemploymentlawyer.ca. Again, pocketemploymentlawyer.ca. Let's use the severance calculator feature, and let's see exactly how much this person is owed. So he's been a machinist for 22 years, say he's 58 years old. We see on the screen there that he is owed not 22 weeks pay, not a week per year of service, but as much as 22 months pay, 22 months pay. Now that's a difference, 22 weeks is, call it 5.5 months. So there's a difference between 5.5 months and 22 months. John, that's a massive, massive, massive difference. That's why we have to be very careful with the employment agreements that we sign. And certainly the most important lesson that I want you to take from this is if you are let go, it does not matter what you're offered. Chances are that the law says you're owed more. You got to give me a call. Let's talk about it. At a minimum, use our severance calculator at pocketemploymentlawyer.ca.
It's interesting because we talk about that employment contract being slid across the desk mid-employment while you're already working for a place. People hear that, they maybe just heard this last segment, and they're kind of nervous because they go, I just signed one too, am I in trouble? It's not always game over, though. I mean, there's certain things that might be able to save their bacon. A, maybe it wasn't drafted properly. B, maybe they didn't get something for signing that agreement. These are all things that can be good for an employee, yeah?
Absolutely. There's a number of ways, at least a dozen ways where we can get around an employment agreement, even though you may have signed it, okay? But we won't know that until the time comes. So it's always a good idea. If you're not comfortable with it, don't sign it. That said, if you did sign it, you didn't know any better, don't assume that now you're stuck. There's a number of ways, and if you are let go, if there's something that your employer is doing in reliance on that employment agreement, let's talk about it. Yeah, we may still be able to get you out of it.
You have all different kinds of ways to reach out on this show. Another one still is terminationquestions.com. We'll read one of those right now, Lior, and carry on with this. Angela, this time, says, I was temporarily laid off at the start of the pandemic, but frequently told I would be brought back every few months. It's been nearly 2 years now. How much longer do I have to wait?
John, this is a common question, probably one of the top 3 questions I've been getting during the pandemic. I've been put on a layoff. I'm not back to work. How long do I have to wait? How long is long enough? So let's be clear. You don't have to wait. So whether it's on day 1 of the layoff or day 155, you can treat that as a termination of employment. Your employer, whether it's in Ontario, in BC, in Alberta, your employer does not have the right to put you on a temporary layoff. In other words, if they do, you can treat that layoff as a termination of employment. You don't have to do it, but you have the right. So when you're asking me when is enough enough, well, it's enough whenever you say that it is, whenever you, the employee, decide to treat that as a termination. Now, one thing I want you to keep in mind, this is very important. There's a 2-year limitation period. So if you've been put on a layoff in the beginning of the pandemic, let's say in March of 2020, then that limitation period expires in March of 2022. So for many people, that limitation period is right here. So you have to be very careful with that. Don't sit on your rights. If you have been put on a layoff, if you haven't been called back to work, now, not tomorrow, not after the weekend, now is the time to make that call, and let's have a chat.
We did mention off the top of the show our main topic for today is going to be employment law concerning federally regulated employees. We will get to that next, but we got to take a short break, which we're going to roll into. The number 1-855-821-5900 to reach out anytime to Lior and his crew. And the email address we always use is simply help@employmentlawyer.ca. More employment law shows on the way. Stick around. People think you have to sign back a severance offer by a deadline. EmploymentLawyer.ca says that is a myth. Deadlines are used as a pressure tactic. Make sure the offer is fair before you sign. Always check with the employment lawyer first at EmploymentLawyer.ca. Can insurance companies deny long-term disability claims for mental illness?
When you're suffering from a mental health disability, insurance companies just don't understand. But we do.
They can absolutely not force you back to work. If your doctors say you are not ready and you know you're not ready, they cannot make you go back to work.
If you have a mental health disability and your claim is denied, don't give up. Give us a call and let us fight for you.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think you aren't owed severance pay if you are fired for a reason. EmploymentLawyer.ca says that is a myth. Most for-cause terminations are false, and you are still owed full severance. Always check with the employment lawyer first at EmploymentLawyer.ca. All right, welcome back. Thanks for sticking around this half hour. Again, pocketemploymentlawyer.ca, yet another website you can use to reach out, have contact, learn more about employment law as it concerns you and your workplace, and also the severance pay calculator is rolled into that website as well. But want to talk about this, employment law concerning federally regulated employees. What does that even mean? How about provincially regulated employees? How does it differentiate between the two, Lior? Provincially, federally?
Yeah. The vast majority of people that work, the vast majority of employees are governed by provincial legislation. They're provincially regulated. So most people, they have legislation and laws that the provincial government enacts, and it's the provincial government that has the right and the ability to enact laws with respect to their employment. There are certain employees, a small percentage generally, that are regulated federally, where the federal government can impose law and has imposed laws and controls the terms of the laws that applies to them. So some examples, banks, employees of banks are federally regulated, okay? So that's a huge employer, many thousands of people work at banks, so those are federally regulated. Other employees, those working at telecommunications, TV, radio, etc., they're federally regulated. Some other examples would be those working in trucking, interprovincial trucking. So if you work for a truck company that goes between provinces or cross borders, that's federally regulated. So most employees know if they're federally or provincially regulated, but it comes down to what laws apply to you. Do the laws of the provincial government or the laws of the federal government? Now, that distinction, as we'll talk about, is not as significant as you think, but it's certainly always a good idea to know if you're federally or provincially regulated.
So we'll break it down a bit. Can a federally regulated employee be fired for no good reason or without a reason?
So generally speaking, for provincially regulated employees, so for most employees, you can be let go for any reason as long as you get paid your full severance. That is a bit different with federally regulated employees. A federally regulated employee can't just be let go just because their employer wants to, even if severance is paid. A federally regulated employee generally can only be let go for cause. In other words, if they did something so bad that it's impossible to continue employing them, or if there's an inevitable business reason, the department is shut down, etc. In those circumstances, a federally regulated employee can be let go. In other circumstances, unlike a provincial employee, the law actually says, the federal employment statute says, you cannot be let go. Now, a lot of employers don't know that. They still assume we can just let you go because we want to. No, not with a federally regulated employee. And because of that, unlike a provincial employee, a federally regulated employee can actually get reinstated with back pay if they are let go improperly.
How about when it comes to a matter of severance? Is the calculation different for a federally regulated employee versus the rest of us provincially?
So if you are let go properly and you're owed severance, the amount of severance that you're going to be owed is going to be calculated in the same way. So a federally regulated employee and a provincially regulated employee are going to get severance calculated the same way, based on your age, your position, and the length of your employment. Now, the minimum entitlements of a federally regulated employee may be different than a provincially regulated employee, but that doesn't matter. Your full entitlements, what we call your common law entitlements, are going to be the same. So you could be owed as little as a month's severance or as much as 24 months severance. It's the same. So it's another misconception that I see often, John, that people believe that somehow a federally regulated employee doesn't get the same amount of severance or gets less severance than other employees.
We talked about earlier in the show changes to someone's job, whether it be their hours, the location, rate of pay, so on and so forth. What are the rights? Is there substantial change when it comes to federally regulated employees? Same thing applies?
So I said at the beginning that there's not huge differences between federally regulated employees and provincially regulated employees, and that's a good example. This concept of constructive dismissal applies absolutely to federally regulated employees. That means that your employer doesn't just have the right to change terms of employment in a significant way. They can't reduce your pay significantly. They can't change your hours significantly. They can't demote you or relocate you. So if that happens, that gives you the right to treat that as a termination. Again, constructive dismissal. That means that you are saying, by doing this, employer, by changing my pay or hours, whatever it is, you've effectively terminated my employment. I am choosing to look at it as a termination. Now you have to pay me severance. So this principle, this concept that we've talked before on the show applies absolutely, not just to provincially regulated employees, it applies to federally regulated as well. In other words, it applies to all non-union employees.
Yeah, you mentioned non-union. That's a good leaping off point for this one more question. We know that the vast majority of people under provincially regulated regulations and rules, they can come to you. That's how you make your business. You help a lot of people. Can the federally regulated, as opposed to a union member, can they come to an employment lawyer like you for help?
So you're absolutely right. Everything we talk about on this show, you hear us on radio, everything we talk about only applies to non-union employees, okay? Yep. We cannot help, no lawyer can help a unionized employee. It has to be the union. And John, every day I get multiple calls or emails from unionized employees asking for my help. And sometimes they get upset when I tell them I can't help them. It's just the way the law works here. It's been the same for 150 years. A lawyer cannot help a unionized employee. But for all non-union employees, federally regulated or provincially regulated, yes, you can get help. You should get help. You must get help if you have a workplace issue, whether you've been let go, whether your job has changed, whether you're not being treated properly in the workplace. Whatever that issue is, you have to get some legal advice. You have rights. The law can't help you if you don't get that advice done.
Advice, reaching out, 1-855-821-5900, help@employmentlawyer.ca. Shrink that down to just employmentlawyer.ca. You get to the firm website, and there you will find links to our radio shows across the country. We've been doing this for almost a decade, so we got a bunch of them. You want to tune into one, you can find it there. Make a phone call while we're on the radio show. Ask some questions. We invite that every week. And we'll get to our, second phone call for today's show from our radio show, Lior, right now.
I have a small business, and it's taken a beating. It's in the service industry, and people are very nervous about coming in and having personal services done. If I have to go under, like if I have to fold the company because we just can't stay alive, I have one full-time employee, one part-time employee. Would I owe them severance pay if we fold because we can't survive any longer? Like, where does the money come from?
It's a great question. Fantastic question. Common question.
And we talk about employees, but we have to remember that there's the other aspect of the employment relationship, and that is employers and employers' rights and obligations. And certainly during the pandemic, a lot of employers are struggling, okay, and have struggled and may even continue to struggle. But here's the thing, when it comes to severance, if you are an employer that's struggling and you let someone go because of that, the severance laws are the same. You don't get a break, unfortunately, or fortunately, depending on your perspective, but you don't get a break because your business is struggling. You don't get a break because financially you're not doing well. The same amount of severance has to be paid whether you're doing amazingly well or if you're struggling. That said, you know the old saying that you can't get blood from a stone. Yep. So if legitimately there's no ability to pay, there's no money, there's nothing to be had, well, I guess you're not paying severance. But keep in mind that an employee that's owed severance can enforce against property that the employer owns, against accounts receivable, receivables that the employer owns. They can access the employer's bank accounts. So it's not as simple as saying, oh, well, I'm struggling, so I'm not going to pay. Okay, an employer has to understand that there is a cost of doing business, and one of those costs is you have to pay severance if you let someone go.
Lots more to come, but we got to take one more short break. We will do that now. We'll give you the number as we go to break. Grab a pen, write it down, put it in your phone, 1-855-821-5900. Reach out anytime you want to have a conversation or seek some help from Lior and his team, or help@employmentlawyer.ca. We'll continue. This is the Employment Law Show. Stick around.
People think you should go to the government to get severance pay. EmploymentLawyer.ca says that is a myth. Government can only help you get minimum severance, but not everything you're entitled to. Always check with the employment lawyer first at EmploymentLawyer.ca. If your long-term disability claim is denied, should you appeal?
Appeals often fail because insurance companies control the process. So long as you appeal, you're playing by their rules.
You should never appeal the denial of your disability benefits. Appeals are just a mirage of false hope.
Don't. That's their process. Take it out of their hands and fight for your rights with our help.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think their employer can make changes to their job. EmploymentLawyer.ca says that is a myth. Your employer can't change your pay, hours, or duties. You may be entitled to full severance pay. Always check with the employment lawyer first at EmploymentLawyer.ca.
Okay, welcome back. Thank you so much for sticking around. Last few minutes of the show. Again, employmentlawyer.ca, firm website, media tab. Find a radio station near you that carries our weekly show several times during the week for an hour. Lots of great information there as well. We take phone calls as well. Lior, phone call number 3 from the radio show is up next.
I worked for my present employer for about 5 years. About a year ago, he deducted my wages, or he knocked them down. It was because we were hauling for different client truck drivers, so product customers. So he said he can't pay as much. It's about, say, maybe 7 months ago. I'm just wondering if there's anything I can do about it now.
So, by the way, this is likely a federally regulated employee, truck driver, and the laws of constructive dismissal applies to him. So no, his employer doesn't have a right to reduce his pay, even if there's a business reason. In this case, the business reason, maybe they lost a client, right? So the employer says, well, I don't have as much money, so I can't pay you. Regardless, the law is the same. An employer does not have the right to change terms of employment. So yes, this would have been a constructive dismissal. Now, I said would have been. And the reason for that, he says that this change happened almost a year ago. The problem with that is by now he's considered to have accepted this change. So if his employer reduces his pay, continues working for a while, then just continues and doesn't do anything about it, now that becomes the new terms of employment. He's accepted it. And if he's accepted it, he can no longer pursue constructive dismissal. So you usually have a small window, a few weeks, 2, maybe 3 weeks to continue working before you're considered to have accepted the change that your employer has implemented. And that's important because if you've accepted it, you can't go back. You can't say, well, you remember 8 months ago when you reduced my pay? I'm going to say that's a constructive dismissal. By then, it's too late. By then, that's an acceptance. That's the new terms of employment. And as I said before, it gets worse. By accepting that change, you've given the company the right to do it again. When it comes to a pay increase, now not only is he making less money, bad enough, of course, but he's given his employer the right to do it again. So if you're faced with a change to terms of employment, let's talk about it. Do it quickly. Don't sit on that. If you hesitate too long, you may be considered to have accepted that change.
Again, don't wait any time. Just have a discussion. Could be a simple phone call, right? 1-855-821-5900, help@employmentlawyer.ca. You can also use the website terminationquestions.com to reach out to Lior and his team, which is where we're going to go now. Well, Lenny is up. He says, I was fired for cause after lodging a complaint with HR over ongoing bullying by colleagues. The termination came as a surprise as there were no warnings or advance notice. What should I do?
Well, an employer can't do this, John, and we've talked about this on the show so many times. An employer must take harassment complaints seriously. They can't ignore it. They can't avoid it, and they certainly can't punish someone because they brought those allegations forward. That's what we call a reprisal. Okay, so if you're now being bullied or you've been punished because you raised the harassment allegation, a human rights allegation, whatever it is, your employer not only doesn't fix it, they pick on you, they suspend you, they let you go. That's illegal. It's a reprisal, which means it's a breach of the Employment Standards Act. That, depending on the situation, that can also be a human rights violation. It's illegal. So this person, Lenny, has all sorts of entitlements. At a minimum, of course, Lenny is also owed severance. Now, that's above and beyond any other damages. So let's focus on that for a second, kind of in the last couple of minutes of the show. Let's see how much severance Lenny is owed. And to do that, you know what I'm about to do? I'm going to go to pocketemploymentlawyer.ca. I'm going to use the severance calculator tool there to see exactly how much severance Lenny is owed. So we know that Lenny is a project manager that's worked for 23 years. You see he's not been offered any severance necessarily, but we see in the bottom that he's owed as much as 2 years' pay, 24 months' pay. Now, he may be owed additional damages because of the fact that he was fired when he shouldn't have been fired, but that's how much severance is owed. And by the way, for you at home as well, if you lost your job, if you're worried about losing your job, if you're just curious to know how much severance you are owed, you can do that right now. Grab your smartphone, your tablet, your desktop, whatever is accessible. Just go to pocketemploymentlawyer.ca and use that severance calculator tool. It's free, it's anonymous, it takes seconds, and it's a piece of information that every single employee should have. You should always know what severance looks like for you.
We got to wrap it up in about a minute. As you know, Lior, let me ask you this one final question. Lenny went to HR. What if you're working for a small mom-and-pop shop and the boss, your direct boss, is the one doing the harassing?
Yeah, so let's say you're being mistreated and bullied by the owner. Who are you going to talk to? Well, number one, I want you to have a way to show that you've been mistreated. Is there a recording? Is there emails? Can you create some sort of a record of it? Because the boss is not going to admit it. Then talk to me and let's deal with it externally, John.
That's the way to do it. If you can't handle it inside, go outside, make that phone call, reach out to Lior and his team. They will take care of you. Indeed. It's really simple. The number, 1-855-821-5900. Again, 1-855-821-5900. The email address is help@employmentlawyer.ca. And for all the employment law matters, including in there the severance pay calculator, pocketemploymentlawyer.ca. It's absolutely free, it's anonymous, and there's tons of information. Before you tune into this and the radio show, you can use that as well. And we'll catch you next time, the Employment Law Show.
Closed captioning of this program is brought to you in part by SeverancePayCalculator.com. Find out how much you are owed right now. SeverancePayCalculator.com.